Welcome, everyone. My name is Federico Tozzi. I'm the Executive Director of the Italy America Chamber of Commerce. And I'm very pleased to welcome Courtney Noce from Greenberg Traurig, their immigration practice, our Senior Sustaining Member, to talk about this very, very important topic. Myself, I am an Italian. I was born in Italy, so I know how important is immigration for people like us coming into this country to do business. And clearly, the new, administration has signaled that there are going to be some changes. So it's very important for us to keep ourselves informed. So thank you very much for joining us. Thank you, Courtney, for making yourself available for this important webinar, and I will let you start. Thank you again.
Thank you, and I'm happy to be here. Thank you all for taking the time to go through this topic, which we are seeing quite frequently in the news right now. There's a lot to cover, so what I'm going to do today is really just try to give you all an overview of some of the things that we're thinking about when we're talking with companies, some of the things that we've already seen take place with the current administration, and then some of the things that we may see moving forward, some immigration compliance pointers that are really critical right now, and then we'll end with questions. If you have any questions, please feel free to type them into the chat box, and I will cover them if I can as we're going through the presentation, or make sure that I cover them at the end. If you have any questions that have private or personal information, please feel free to send me a note afterwards as well, and I'm happy to talk with you offline so that things remain anonymous. So when we go through what is happening in immigration, it's always really helpful initially to go through what government agencies actually touch immigration. We talk about a visa, a stamp, DHS, all of these different things. So if you look here at the government agencies, you'll see Department of Homeland Security, Department of Labor, Department of State, Department of Commerce, and Department of Justice. And all of these agencies play a different role in immigration. You'll also see underneath those circle bubbles that there are different agencies within those. So if we look at Department of Homeland Security, we're going to have USCIS, which is a big one for us in immigration, and we're also going to have U.S. Immigration and Customs Enforcement, or ICE. So here are a few of those with which we interact more frequently. Some of these may be agencies or terms that you have been familiar with for those of you who have brought individuals over on visas, if any of you on this call have been on visas yourselves, or really if you're just seeing some things in the news now based upon immigration and understanding what's happening there. So the Department of Homeland Security, or DHS, houses USCIS, that's our benefits arm in the United States. So when we are asking for a benefit for a worker in the US, like an H-1B or sometimes an L visa, that's going to be where we are going to request a benefit. We have ICE, that's our enforcement arm. So when we're talking about individuals that are coming to investigate or to do audits, or if you have seen in the news raids, that's going to be ICE. Again, they're an enforcement arm. And then we have CBP. That's ultimately the group that is safeguarding our borders. So if you engage with an officer when you're coming in with your visa at the airport, you are speaking with a CBP officer. And then finally, the U.S. Department of State is where we see the consulates. So anyone who is going to a U.S. consulate to receive a benefit, it could be a visa stamp that they're receiving. It could be that they are going to have a petition adjudicated and receive a visa stamp. So they may be going to get an e-visa at the e-visa unit. Maybe they've been approved for an H-1B and they're going to get their H-1B. The stamps are going to be controlled by the Department of State at the consulates. So with that, I'm going to take us into the immigration executive orders. So when President Trump was preparing to come into office. And of course, during the campaign process, he focused very much on immigration. So we did expect that when he took office, we would see a large number of immigration executive orders. And we saw this last time as well during his last administration. So what I've done is I've put up these executive orders. I've put them in italics so you can tell that that's what they are, because we'll move on to a couple of additional slides where we also have a few of these I'm going to dive a little bit deeper into because they impact companies a little bit more on a daily basis. But we have protecting the United States from foreign terrorists and other national security and public safety threats. We have the America First trade policy. We have guaranteeing the state's protection against invasion. We have designating cartels and other organizations as foreign terrorist organizations and specially designated global terrorists. We have protecting the American people against invasion and protecting the meaning and value of American citizenship. So a lot of these executive orders are focusing on individuals that are not within the United States with valid status right now. You've seen a lot of that in the news. I'll talk a little bit more about that, of course, in the compliance section as well. And then the other executive orders are definitely focused on security and tightening within the immigration system. So some of these are concepts that we saw during the last administration, and some of them are a little bit newer. One executive order that I wanted to touch on with a little bit greater detail is the America First trade policy. So this is also where we talk about Buy American, Hire American. For those of you who saw immigration in the initial Trump administration, we refer to this as BAHA for short. And this overarching theme is that we focus on giving priority to US workers. So in connection with this recent executive order, the U.S. Trade Representative has been directed to review implementation of trade agreements to ensure that they favor domestic workers and manufacturers. And this really could have an impact not only on the visas that fall under trade policies, so those TNs for Mexico and Canada, but also e-visas that fall under our Treaty of Trade and Friendship with Italy. And BAHA in general, last term did impact H-1B adjudication. So when we talk about this, we see a potential impact on a lot of these non-immigrant visas. So our non-immigrant visas are essentially our visas that give us a temporary period of work authorization. So these L's are going to be our intercompany transfer visas, our H's are specialty occupation visas, the E's, the treaty investors or traders, and then the TNs that I mentioned. So this is really where we're going to see more significant looking into criteria, more substantial pushback during adjudications, and more thorough review of the matters in general. I've also put up this executive order protecting the meaning and value of American citizenship because we have received a very large number of questions about this. So for those of you on the call that may not know, if someone is born in the United States, they are automatically considered a US citizen. And that's going to include individuals who are born in the United States to parents who do not have US citizenship and may even be here on a temporary work visa or without status in the United States. And so this executive order is seeking to reinterpret the Constitution's guarantee of citizenship for those individuals. And more specifically, it really attempts to remove that automatic grant of citizenship to certain people who are born here. Now, again, this is in the Constitution, so lawsuits have already been filed challenging this executive order, and it is not currently in effect, meaning that someone who is born in the United States right now is still going to be granted that citizenship. So this is an area when we're looking at executive orders, which is important because I'll talk a little bit more about this in terms of certain programs that the administration is challenging. that there are going to be, in some instances, challenges to the executive orders. So really what we're trying to do when these announcements take place is look and then see what the response in the court system may be. So it does not mean that just because we have an executive order, there is an immediate impact. Some of them are much more likely to have immediate impacts than others. And then when things are challenged in the court system, we could have various outcomes. And that's really just going to depend on the details of the orders themselves. So if we're talking about impacts, which I would imagine is one of the reasons that many of you are on this call today, to try to understand what these executive orders are actually doing. We can really look to some of those immediate impacts that I mentioned. So that's going to be where we have an immediate change because of one of the executive orders. So where we're seeing this initially is limitation and or elimination of certain programs. So I'm gonna talk a little bit about that. Those of you who have businesses in the United States, you may have individuals who are working with you based on a temporary status or permission to be in the United States that gives that individual work authorization. So TPS is a really common one. And this is one that we've had in the United States for quite some time. And it is exactly what it sounds like, temporary protected status. This is where we have countries that are not in a state of safety or calm for individuals, either because of political unrest or natural disasters, war, etc. And the US government has indicated that individuals from those locations are eligible to remain temporarily in the United States and to work in the United States. So this has been an area where we have seen a call to end certain programs. So two programs that you may have seen in the news, initially Venezuela, and after that, most recently, just I would say, I think it was last week, Haiti. These are TPS programs that will be coming to an end. So what does that mean? Some people have been here on employment authorization documents for quite some time in connection with these programs. And oftentimes they don't have alternative forms of status or work authorization that they will be able to use. So what we are telling clients in general is to be aware of the fact that this may have an impact on your workforce. Depending on the industry, the impact may be higher or lower, but we will see a decrease in individuals who have work authorization as these programs are ended. There are differing end dates for the program. So when we're looking at something like this, we have a different end date, exactly that, for different programs. So it won't be that you will have everyone all at once, but it's something to continue to watch and something to prepare for. You may not know that these individuals are on something like TPS if they don't let you know that. And so it is something in general from a business continuity perspective that's important to be aware of and to try to plan for to the extent you can. Asylum, which is a legal concept that exists in many countries. We here in the United States, of course, have a lot of individuals that seek asylum. There has been a lot of news surrounding asylum in general over the past many years because we do have a large number of asylum seekers that come to the southern border in the United States. The border program note that I've made here is that there was a program in place for people to schedule appointments and come and present themselves at the border. That program has been paused for now. So there is a good amount of talk about asylum and people who are seeking asylum, either who have already entered the United States or attempting to enter the United States. And then finally, we have the refugee program. So this is really where individuals are applying for in advance and receiving approval to come in as refugees to the United States. This program was called to be terminated, and that termination was challenged in court. So that is still out there being challenged, but that's another example of where, we may have these TPS programs that at this point in time, that effect is going into place, but the refugee program change is one that's challenged at this time. So we will have to see what happens there. Another impact that we are seeing is increased arrests and removals of individuals without valid status. So this is really where we are seeing that immigration and customs enforcement come into play. We have officers that could be showing up, and I'll talk about this a little bit later in greater detail in the compliance section, but individuals that may be coming to look for specific individuals at places of business, or we have seen instances of this at schools and universities. They may be coming in what we refer to as a raid to look for individuals that are working without authorization. And we also see increased arrests and detentions surrounding traffic stops, et cetera. So this is a heavy manpower effort, and that's why you also hear in the news a lot of discussions surrounding immigration funding, where these resources will come from, deputizing individuals to have authority to take action, because we do have a very real resource issue in terms of people being able to actually make a significant impact on the number of individuals. So in line with that, I have a lot of questions that come up surrounding what increase are we actually seeing, right? And depending on the source that you look to, we can see that I've heard it cited that we went from 300 to 600 arrests, or 300 to 900 arrests. I think we don't really know what that looks like. It's definitely certain that we're seeing more activity. And in addition to more arrests and removals, we're actually seeing more removals to third countries. So for those of you who have been following the news surrounding countries that have been accepting individuals who are being deported from the United States, this is something that we really didn't see as much during the initial Trump term. And that has to do with the fact that even if someone is in the United States without authorization, that doesn't mean that it is necessarily easy to remove that individual to another country, or to their home country rather, if their home country will not accept them. So what we've started to see, and I know that various news outlets have been doing stories on this, are removals to third countries such as Panama, who are accepting some of these individuals. And then the point which I think is the most critical for the compliance portion of this for individuals who are on the call, this increased worksite investigations, which are primarily focused on identifying undocumented workers. And I will talk to you all a little bit more about that, because we are receiving a lot of calls from clients who are concerned about what they should be doing from a compliance perspective. So here I wanted to talk a little bit about what we are thinking about and what we are talking about with clients as potential future impacts, because a lot of these executive orders really called on stakeholders to come back to the president with information, and that information would then lead them to make certain determinations and implement certain policies surrounding some of these executive orders. So one thing that we do expect is stronger vetting of visa applicants at U.S. consulates abroad. And when we have that stronger vetting, we are most certainly going to have a situation where we have increased denials and longer visa wait times. So we are talking to our clients about making sure that we plan well in advance for individuals who are going to be going to consulates. So this doesn't mean, I say here increased denials. It doesn't necessarily mean that we're going to have a large number of denials, but a stronger vetting may be holding a higher level of requirement for certain things, and I'll talk about that again in a little bit. But visa wait times, most certainly. Those of you who have been either on a visa or filing visas for your company for some time, remember that we had longer visa wait times during COVID based upon operations. We also have longer visa wait times in certain locations, just based upon what the demand is there. If we have certain world events that are in place and there are demands placed on a consulate for processing, that's going to slow things down. We also, of course, have natural situations where people are going to retire and move on, and there's natural training that occurs for individuals who are new to the government, and that may mean that processing times take a little bit longer as well. Another aspect here is the potential hold on visa issuance to countries that are considered a threat to U.S. security or trade. And what I'd like to do is talk just a little bit about the difference in hold on visa issuance versus administrative processing during visa issuance. And administrative processing is something that we have. It's always out there, and it typically occurs for one of a few reasons. One may be because an individual has traveled to countries that are of concern to the United States. The other may be that they have an education that is of concern, or they may have a name that is similar to someone who actually does have a criminal history. And so visas will be put into administrative processing for security purposes so that the consulate can receive clearance from an agency in the United States that this individual does not pose a threat. And that can add processing time. Now, if we're talking about Italy, the frequency of that happening in Italy is much lower than it would be in China, for example, where the instances of administrative processing are quite high. But we also see, and what we saw during the last administration, which was referred to by many as the Muslim ban, is that we do have the president's ability to put on hold visa issuance for countries that seem as if they will pose a threat to U.S. security and trade. This is one of those situations where stakeholders are reporting back on security in various countries where the U.S. consulate issues visas. And should that be a concern, we could see future holds on visa issuance. So this is something that we are watching. Another impact at the Department of State is that consulates, when they're busy like this, or when a lot of times they're dealing with security issues, they are less likely to grant expedite requests and emergency visa appointments. So it can be much harder to actually get someone in for a faster appointment time if you're trying to mobilize them quickly, or it can be harder to request some of those very last minute appointments. And what that means is really in line with the theme of what we are telling clients all the time is be proactive, plan in advance, and start those things early so that you are well in advance of the time that you may actually need your visa application. For critical processing and processing that may only occur at the consular level, like e-visas, we really don't have a way of making that faster by going to a different consulate to process something either. So an e-visa unit is going to be as fast or as slow as their workload permits. And so we can see varying levels of processing times. And if we look back over e-visa processing in Italy over the past 10 or 15 years, for example, we have seen visa processing times as short as a month and visa processing times as long as over a year. So we really can see great flux in how quickly officers are able to look at these cases, which means that we want to apply early. Fortunately, the visas in the United States, E-visas, H's, L's, et cetera, those visas are not going to have a time period within which you must activate or send a traveler. So if you get a visa a little bit earlier than someone actually is going to be getting on a plane, that's typically okay. Of course, you need to speak with your immigration attorney about that and make sure that everything you're putting in your petition and your request is valid and accurate, but you can oftentimes back out those appointments and filings so that you're getting in there earlier so that you're not going to be in a rush situation on the back end. That's also really critical when we talk about expirations and renewals as well. Right. So with that, I'm going to move on to the potential impacts with USCIS. So a reminder that USCIS is the benefits arm in the United States. So if we're applying for green cards, if we are applying for individual L visas, H-1B visas, O visas, this is all going to go first to USCIS before the individual then goes to the consulate to request their visa stamp. So what do we expect could be potential impacts at USCIS? Based upon the last Trump administration, we did see an increase in RFE, which is request for evidence activity, in NOID activity, which is notice of intent to deny, and also denial activity. So what are these? I'm just going to speak briefly on what these actually are. So when we file a case with USCIS, they can approve it, they can deny it, they can request for evidence it, or they can send us a notice of intent to deny and give us the opportunity to provide evidence showing that we merit the approval. So basically what this is immigration asking for more information than typical or than they were in the past to prove that we deserve an approval of the category for which we are applying. So that is something that, again, we did see last time. And it doesn't mean that it's problematic in terms of presenting information, but it does mean that it's going to take a little bit more resources from you all as organizations. You're going to have to pull documentation that seems like it may be a little bit much or a little greater detail than potentially you've used on cases in the past. And then, of course, it can lengthen times because once you respond to those requests, then immigration has their time to actually consider what you've presented and make their final adjudications. So if you are using premium processing on certain things, then you can control this time period a little bit more. But if you cannot use premium processing on a particular item, then you're not really going to be able to impact that. So, where are we seeing use of premium processing and where are we not? We see a lot of premium processing used for L visas, for H-1Bs, and for O visas. Very common. We do not have premium processing for the Department of Labor. So I know this says USCIS here, but for those of you who have helped put someone through the green card process or potentially been through the green card process yourself, oftentimes we're using the Department of Labor if we're doing a labor market test in connection with that green card. The Department of Labor does not have a premium processing option. So what we've seen is the timeline for what is in general a USCIS process, but requires the Department of Labor to become quite long. And this is a really good pointer to know because it can lead to frustration from employees who are being sponsored for green cards, or really frustration on your part with the company because you can't control how quickly these cases are going to process. And if you have employees who speak with one another, they may have very different experiences with the process because of the different processing times. Another thing that we may see, I would imagine that a lot of people on this call may use or have used L1 intracompany transfer visas in the past. So we did see a more restricted definition of specialized knowledge and managerial during the initial Trump administration. That could be something that we see this time again. The reason that I say maybe something is that it typically takes us a little bit of time into an administration to actually see some of these changes take effect. So we know what the focus of the president is. He has let us know what that focus will be, but for things to filter down and actually change in a real practical sense with these adjudications, it will take time. So we still may not see if or when these changes or impacts could be felt for a few more months. And of course, it's possible that we don't see some of these impacts that we saw last time, but it's likely. Other potential changes are to the H-1B program, including what's considered a specialty occupation. So we did see probably the highest level of requests for evidence during the initial Trump administration on H-1Bs and also on L visas. Those were probably the areas where we saw the need to present a much higher amount of information than in the past. So what does that mean from a planning perspective? In addition to planning ahead, as I said, you also should plan for higher sponsorship costs. And why is that? That's because the government is going to, in some instances, request more information, which means that it will take longer and be more costly to actually prepare a visa application. We have also seen, and we see this throughout all different administrations, so this isn't specific to the Trump administration, but we've seen an increase in government filing fees over the years that has been quite dramatic as well. And the reason for that is because immigration benefits are a user-funded service. So the officers who are adjudicating these petitions are being paid by the user-funded portion of this. And then also extended processing time. So I talked about that a little bit. Other potential impacts that are more miscellaneous in general would be changes to the TN classification for Mexican and Canadian nationals. We could see a more stringent definition of manager or essential skills, which is important for those of you who may have e-visa workers or may be applying for e-visa workers. We could see DACA changes. That's the deferred action for childhood arrivals. So this is also a temporary work authorization that certain individuals may have, and something that is important to understand may impact work authorization and available workforce for your companies. And then, of course, U.S. foreign relations with each country may impact classification. So that's been something that we have seen in the news a lot. Lot of talks with different countries, lots of potential changes. And of course, there's a concept called reciprocity in immigration, and U.S. nationals are requesting visas in other countries. Other foreign nationals are requesting visas to come to the United States. We have trade agreements, et cetera. So all of these things do, of course, impact what benefits we have and how certain benefits may be viewed. I wanted to talk about J visa considerations because I know many of you on this call may have used the J visa program in the past or may be considering using it in the future. So we're really lucky that the Chamber has a J visa program. The J visa program is one where we can bring business trainees and interns to the United States, and we must have a program sponsor. And then the company is the host. So here we also want to plan in advance, because once the Chamber does the paperwork, an individual is going to have to go to the consulate. And we, of course, may see those consular delays that I mentioned that are not specific to a visa category, as well as heightened security. You also want to make sure that you have enough time for the sponsor to be able to explain what's necessary for the J visa program and understand if you have any red flags in your cases or anything that could be of concern. We could see changes in consular adjudications or toughening surrounding certain applicants that are going through the program. So this is really where having a good partner can be very critical to success. and trying to anticipate some of those potential delays in visa stamping and help you plan for what a timeline may look like. So here I've included Erica's contact information. So if you have additional questions about the J-1 visa program, which can be really wonderful for bringing over younger workers, absolutely recommend that you reach out and speak with them. Also, if you have any concerns about time frame, et cetera, a great opportunity to do so. So with this, I'm going to move into immigration compliance, which is one of the, I would say, most newsworthy topics right now, and probably the topic that is keeping most of our clients up at night. As organizations and companies, you want to make sure that you're doing the right thing. And in most instances that I've seen, companies are truly trying to do the right thing, but it can be confusing what you should be doing. And it can be confusing how to prepare for potential investigations, because even if you're not doing anything wrong, it can still be scary to have an officer come to your place of business and you want to understand what you need to do and how to handle that. So there are three primary types of immigration inquiries that we see. USCIS site visits. So that's when an officer is going to come to the work site based upon one of those benefits that has been requested from immigration. We have Department of State phone and email inquiries when someone is visa stamping. And then we have ICE visits. And ICE visits are the ones that are of greatest concern to people right now, just in terms of not really being certain what to do. So I'm going to go through these different types of immigration inquiries in a little bit more detail. So the purpose of a USCIS site visit is to verify that a company and foreign national immigration-sponsored employee are complying with the terms of the visa. So what does that mean? That means that the employee and the petition that was filed on their behalf, that the company was being truthful in that petition, and that the employee was being truthful in that petition. So these are typically unannounced, and they are conducted by an FDNS officer. So the officer may ask to see the work site and or speak with the sponsored employee. And this may happen in an office. If you have individuals who work remotely, this may happen at their home site as well. So it's really important to make sure that when you have a visa, if there are material changes to that visa, for example, we're on an H-1B and someone moves from Miami to New York or something like that, that we're updating that visa as necessary, if necessary, because that would be necessary for some visas and not for others to update, so that the government has the most accurate information. When we do that and we are complying with those rules and keeping immigration updated, then USCIS site visits are really nothing to be concerned about. An officer is typically going to be quite friendly. They're just trying to understand that companies are complying. The reason that this program exists is because it's actually extremely effective at vetting out fraud. I have a colleague who loves to talk about the case where there was a software company, I believe, and a lot of engineers all on H-1B visas. And when an officer went to check and do a site visit, the location that was provided was actually a pizza shop and was not a software development company. So you'd be surprised that that people will put through fraudulent requests, and this is really designed to help vet that. The Department of State, where we're receiving our visa stamps, also has fraud controls. So I talked a little bit about some of the security controls and the fact that we may have delays in processing for administrative processing, but that's really something that's being triggered that the Department of State doesn't control the fact that that security check needs to occur. The fraud controls that they do control, so to speak, are to confirm that the appropriate employer-employee relationship exists. Oftentimes, in order to issue the visa, they'll make sure that the legal name of the company is correct, the job title, job description, offered salary, work site address, etc. And sometimes the Department of State will reach out via phone or email to the company to make sure that what an employee is presenting is accurate. And the reason for that is that we have seen instances in the past where individuals going to visa stamp will use fake or fraudulent documentation from US companies in connection with requesting their visa stamp. So inconsistencies in some of these things may result in a visa denial. If someone has a visa approval and is going to visa stamp and there have been some changes, please make sure that you speak with your attorney about what is going to be necessary and what you may need to do in that situation to ensure that there won't be any issues ultimately with the consulate. So now we'll talk a little bit about ICE. Just like we have three major forms of immigration fraud or security or actions, so to speak, we also have three main actions or reasons ICE would show up or conduct a site visit. So one is to locate or take into custody a particular individual. So this is going to be based upon their concern surrounding a particular person or based upon a report of a particular person, but this is very specific and targeted to one individual that they will come to see. The other reason that immigration officers could show up would be to perform inspection of I-9 documentation. This is what we refer to as an I-9 audit. So every company who is hiring individuals must complete something called a Form I-9 for those individuals. If we have anyone with small companies here on the line and you have not been doing this, you must do Form I-9 for everyone. This is different than E-Verify. So E-Verify is a different system. E-Verify has its own rules in different states on whether it's mandatory or not, depending in most instances on the size of the company, but I-9s are always required. And the I-9 purpose is to demonstrate that an individual is authorized to work in the United States. So it's going to verify both their identity and their authorization to work. We see ICE officers show up to perform an I-9 audit because they are requesting to look at these forms and understand if the individual or if the company rather has completed the forms in a proper fashion, and also if there are any individuals who are working for the company who are not actually authorized to do so. And the third instance would be to perform a workforce enforcement action, and that's what we refer to, or you will hear in the news referred to as a raid. So in an I-9 audit, what happens is ICE delivers a notice of inspection and typically a subpoena that requests copies of the forms and the supporting documentation. And then if you are an E-Verify company, E-Verify paperwork as well. They're going to look at the documents and see if there are any errors on the forms. And quite frankly, the forms oftentimes will have errors. This is in particular for companies who still use paper forms. We always joke that this is one of the most complicated, simple short forms on the planet. And there's two types of errors. There are errors that can be corrected, so they're technical violations. And then there are errors that cannot be corrected, and those are considered substantive violations. So late completion, for example. A company is going to be subject to fines for I-9s that have errors. And even if a company correctly verifies work authorization for all employees, ICE could still come. So ICE is not coming for an I-9 audit necessarily because they feel that you have done anything wrong, or them showing up doesn't indicate that you have done anything wrong. It's more of a compliance paperwork check So it is really important to make sure that you have proper I-9 training in place, that you have I-9s. It's a great time to do an internal audit and check your forms. You can work with your immigration attorney to do that as well. And then just make sure that you are what we refer to as I-9 or audit ready. So if an officer does show up, you have a plan in place to provide them with the documentation that's required without it being a huge scramble and hassle to you all as an organization. So we do a lot of work in this area, and the I-9 compliance component has always been really critical. This is not something that is new or something that has changed with any executive orders or the new administration. It's just become more front of mind and more of a priority for the current administration, which means that companies are more likely to have an I-9 audit. So you want to be prepared for that. ICE raid. This is the one that is in the news. This is the one where we have a lot of clients, most certainly in restaurants, retail, etc., where we see a heightened risk. And what do I mean by that? The government understands that there are certain industries where individuals have been working without authorization in higher percentages. And so oftentimes they are going to start with those industries in terms of targeting individuals and trying to find companies that have individuals working without authorization. What will happen in this? ICE officers are going to come to a place of business with a search warrant. ICE officers are free to enter any public areas of the workplace, but they must have a valid search warrant or company consent to enter non-public areas. So a lot of the requests and questions that we are receiving right now are surrounding what you do as an organization if someone shows up either at your company headquarters or your restaurant location, one of your retail stores. And if that happens, you have certain steps that you should take. We most certainly want you to notify your legal counsel, but there's also certain things that you may ask for, and understanding what's considered a public area and what's considered a private area and what an officer must have to then enter those private areas is going to be important. So you do want to make sure that you are preparing individuals who are going to be on site, who may be that first line of communication with an officer who's going to show up, what they need to do, and that may be calling a particular person with the organization. So you don't want to have an ICE officer show up and not have an internal plan. The warrant also must be signed and dated by a judge, and it's going to have a time frame within which the search must be conducted. It's going to have a description of the premises to be searched, and it's going to have a list of items to be searched for and seized. So there are most certainly recommendations that we have about what you should do when that is the process. So what should you do when an officer shows up? What should the individual be doing? We recommend taking notes on anything that is taken, etc. So if you are in an area or an industry where you may be at heightened risk for this, then I highly recommend that you speak with an immigration attorney just to understand what your risk level may be. Do you have a plan in place, and how can you best protect your company and your workforce? And also, what does that look like from a business operations and interruptions perspective as well? So I wanted to go through some compliance reminders before opening it up for any questions that people may have. What, in summary, do I recommend? Preparation is critical. I have preparation is critical with an exclamation point because I feel very strongly about it in compliance reminders, but really preparation is critical for visa stamping, for visa applications, for planning purposes. We're not going to be able to make certain things happen as quickly as we could in the past, and things are going to take a little bit longer for reasons that are outside of the control of you all as organizations, outside of the control of your employees, and outside of the control of any attorneys who may be helping you with things. In connection with the compliance portion of preparation, you really want to make sure that you have company policies in place and that you consider internal audits. So when we're talking about I-9s and officers coming and having an I-9 audit, they are going to ask for policies, or they may ask for policies. If they do give you a notice of intent to fine on your Form I-9s, that's going to be a negotiation process. So they're going to look at companies that are trying to do the best that they can, that are showing that they've tried to be compliant, that they've tried to comply with their rules and responsibilities as an employer with respect to these individuals. And that can downwardly adjust fines that are ultimately owed to the government. It's also great to do an internal audit because it's going to give you some line of sight on whether or if you have a concern and what that dollar amount could look like. I mentioned earlier that from an I-9 perspective, we have some errors that can be corrected and some errors that cannot be corrected. So if there's something where there's not much you can do about it, understanding the volume of errors that you have and what that's actually going to mean. Always notify legal counsel if ICE arrives at the work site for any reason. You want to make sure you call. You can let them know that you're going to call your attorney. That is completely permissible. And then once you have that plan in place, your counsel can help you with the particular type of ICE visit as well. And then I just have this here again with the information surrounding the warrant because it is a reminder. I think this is one of the most frequent questions that we have right now. People are very nervous about ICE officers showing up. We are seeing this happen. We are seeing it happen in a variety of different cities. There's really nowhere that is completely exempt from this. Of course, you will see in the news there are some locations that are experiencing this more frequently than others, but it is most certainly something to watch and to take care about and have a plan in place so that everyone isn't surprised. And with that, I know we only have 5 more minutes before the end of our presentation. I do have a couple of questions that I see that I'm going to go ahead and answer. And if I don't get to anyone, please feel free to email me after the presentation as well. One question was surrounding any changes to the K-1 fiance visa. I am not anticipating any changes to that right now. Fortunately, we're not really seeing that as being the target at this point in time. So if you have a K-1 that's processing, which is a quite long process, then there's nothing that we're expecting there. I also have a question about whether current green card holders are in jeopardy. So there is nothing right now that is leading us to believe that anyone with a green card at this point in time is going to be in jeopardy. We're not seeing anything where the government is proposing taking a look back at green cards that have been granted or anything of that nature. So if you are to green card and you have that, then as long as you comply with the terms of that green card, meaning you're not outside of the United States for too long of a period of time, or engage in some criminal act that is going to result in the revocation of your green card, then you'll be okay. For those of you who may be in the green card process, I know I mentioned the perms are taking a long time. Green cards in general are taking a pretty long time. Sometimes what we see as well is a request or an increase in requests from employees to have the green card process commenced for them, because if we're seeing a little bit more uncertainty in traditional work visa applications, individuals may want to become green card holders so that they're not concerned about those extensions in the future. Also had a question about workers with a fake social security number. So that's really something where if you're receiving social security mismatch letters, for example, which is something that's common, we would want to make sure that you had a process in place giving individuals the option to correct that or to come forth with a proper social security number. The I-9 portion and E-Verify portion of compliance will also catch that in some instances. And if this is something that you're catching when you are going through an audit, it would be, how are you understanding that social security number is fake? So one thing I would recommend for anyone who does have concerns about fake social security numbers, fake documentation, etc., please feel free to reach out if you want. I'm happy to have a conversation with you about your specific circumstances and what the risks may be there, and kind of what that looks like from a business protection perspective and also an operations protection perspective. Have a question about whether there will be access to the recording or the slideshow, and we will have the slideshow. I'm happy to share that with individuals, and I will have the chamber answer about whether there will be a recording.
Yes, so we're gonna follow up, and we're gonna send you the link to today's webinar recording, and yes, we're gonna also share the slides.
Perfect, thank you.
So if there aren't any more questions. Okay, then thank you, Courtney. Thank you very much. It was really interesting. And thank you everyone for attending today's webinar. So yes, we're gonna follow up with an email, and don't worry, you're gonna get the slides and also today's recording. So thank you again and have a nice day. Bye.